Hello, this is Dr. Herskowitz again, and this video we'll be talking about contracts, the really heart of doing business in America. So there'll be two videos on this, a part A and a part B for Chapter 8, and then we'll go into Chapter 9 talking about breach of contract and enforcement. Basically, the learning objectives will be to understand the basics of contracts, to understand the foundation, the different types of contracts that there are. We'll go into some of the theoretical background, and then we'll talk about the actual contracts themselves, how they're formed, how they're offer, acceptance, consideration, all the things that are needed for a valid, binding, and enforceable contract. Okay, so let's get started. These are the specific learning objectives that we'll be going over on Chapter 8. So, what is a contract? A contract involves a promise or a commitment or exchange of promises or commitments to do or not to do something. Pretty straightforward. Believe me, it gets a lot more complex as we go forward. Contracts don't have to be formal written documents. There are oral contracts that are allowed. Contract law enables private agreements to be legally enforced by the public enforcement agencies through the court system. They provide flexibility and precision in business dealings so that you know what you've done, how you're doing it, and you can expect the other person to follow up on their side of the commitment, and if not, you have resources available to either recover losses or force compliance. Contract law comes either from legislation, the UCC, the Uniform Commercial Code. We're not talking much about that in this, but that really deals with retailers and people that are in commerce. And there is also contracts for basically for goods. Common law is really where a lot of the legislative law comes from, and this is judges' decisions, contracts that have been done for decades, hundreds of years in fact, and they set up the common law as for enforcement and binding of the contracts. Different types of classifications of contracts. You have a bilateral and a unilateral contract. Bilateral is where it's a promise for a promise, and unilateral is where it is a promise for performance. You also have express contracts, those that are clearly written out or orally stated. And then you have implied in fact contracts. We'll be talking about that in a minute. And then you have implied in law or quasi-contracts. And this is actually comes from the legal side that says that when something happens, there should be some fairness to compensate a party that may have relied on the other party. So it's a quasi or an implied in law contract. Okay, bilateral contracts. This is the ones that we're most familiar with. It is a promise for a promise. Paul's promised to deliver a laptop computer to Pearl, and Pearl promises to pay for that computer. Pearl has a right to get the computer, and Paul has a right to receive the $1,000. If either of them breach the contract or don't perform, there will be enforcements allowed to make sure that that contract is enforced. A bilateral, this is a unilateral is a promise for performance. Pat's promised to pay Alex $1,000 upon performance, and Alex's right to receive the money if he performs. One party has a duty to perform if the contract is formed by performance. There's no penalty for non-performance on the one party's fault because the contract is not binding until the actual performance. But once it is performed, then the terms of the contract are binding on both parties. The promising party may terminate the offer up until performance. We'll be talking about that with offer and acceptance. But the one thing about a unilateral contract, it can be terminated at any time prior to the actual performance. You have express contracts. These arise from the parties sitting down and agreeing on what they want to do. You have implied in fact contracts. This arises from the conducts of the party rather from the words itself. Take a look at the case of Layden v. American Accreditation Healthcare. This was an implied in fact agreement, is important means of ensuring that one party does not get the benefit of a contract without compensation to the other party. Implied in fact agreements must contain the same elements of express contracts. When an agreement concerns an expressive idea, courts must differentiate a claim from the contract, a copyright claim from a contract claim. You have implied in law or quasi-contracts. This is a judicial remedy to avoid unjust enrichment to one party. The remedy applies when no actual contract exists, but one party actually performs some action, giving some benefit to the other party, and that party allows that to happen. This is what's called an equitable remedy. We have remedies at law and equitable. We won't go into that in any detail, just for those of you that understand the difference. A quasi-contract is an equitable remedy, and it is applied very, very sparingly. You also have contractual performance terminology. You have an executed contract, and that's when the contract is finished. The parties have performed their promises. There's no further obligation by either party. Then you have an executory contract, and the parties have not yet performed their agreement. So the agreement is in place, the contract is in place, but the contract has not been completed. This is very important for such situations such as in bankruptcy, where there are special regulations and special ways of dealing with an executory contract. And an executory contract, by example, would be a lease. You're leasing a piece of property. You pay lease payments every month. That contract is being performed, but until the actual, if it's a one-year lease, until the lease expires and you've made all your payments, it is then an executed contract. But if something happens in the middle of that contract, it's an executory contract. Okay, that's all of Part A, fairly short. Just wanted to give you an introduction to contracts, and then do Part B. We're going to be looking at offer, acceptance, how we have an agreement, consideration, and capacity. We'll be discussing all of that in the next video. Thank you very much.